Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bashar. Today I read the case South Carolina Green Party versus South Carolina State Election Commission, 612 F3D 752, Court of Appeals, 4th Circuit, 2010. Friends, today we're going to talk about sore loser laws, particularly in South Carolina. So for those of you who don't know what sore losers are, stay tuned so you can find out what they are. For those of you who know what they are, stay tuned as well so you can find out how they apply in this case. Our friends at the Green Party are at it again, this time in South Carolina. Way to go. So let's read from the record to find out what happened. It says, quote, Eugene Platt and the South Carolina Green Party challenged the constitutionality of South Carolina's sore loser statute, as applied to Platt's Green Party candidacy for the South Carolina House seat 115. The district court upheld the constitutionality of the statute as applied to Platt's candidacy, end quote. And then it continues, it says, quote, in 2008, Platt sought to become a fusion candidate in the election for South Carolina House seat 115, seeking the nomination of three political parties, the South Carolina Democratic Party, South Carolina Green Party, and the South Carolina Working Families Party. On March 17, 2008, Platt filed a statement of intention of candidacy with the Democratic Party. 10 days later, he filed a similar statement with the Working Families Party. On May 3, 2008, Platt filed an additional statement of candidacy with the Green Party. At the same time, the Green Party chose Platt as its nominee during a state convention. On May 10, 2008, the Working Families Party chose Platt as its nominee. On June 10, 2008, Platt lost the Democratic primary election. After Platt's loss in the primary, the South Carolina State Election Commission, notified Platt that based on South Carolina's sore loser statute, SC Code 7-11-10, his name could not appear on the ballot for the general election as a nominee for the Green Party or for the Working Families Party, end quote. I've never seen somebody in one of these cases run for the position of three parties. These fusion cases, we've done a couple of them on this podcast, usually involve two parties. But this time, someone wanted to run under three parties. So I admire the ambition of Mr. Platt here. We can see from this case, sore loser laws are important to third parties. And also, if you visit, for example, the SAM Party's webpage, they have a section dedicated towards overturning sore loser laws. They have different electoral reforms they want to overturn, and sore loser laws are one of them. So therefore, this emphasis matters to us. This case mentions how Mr. Platt got the Green Party nomination. After the Democratic won. So the order was reversed here. Our friends are saying this violates the First and 14th Amendment. A number of cases, in fact, the vast majority of cases we've discussed on this podcast involve our friends at the third parties invoking those First and 14th Amendments. So we like to see that. You're sick of me saying that by now, but we need to say it because it's a theme that can help us out. Getting back to what I was saying earlier about the order, it says, quote, on appeal, the plaintiffs argue that the sore loser statute is unconstitutional when applied to the Green Party's nominee Platt because he successfully secured the nomination of the Green Party before losing his attempt to become the Democratic Party nominee, end quote. Do you think that matters? If you're opposed to sore loser laws, you probably want them overturned no matter what, but maybe you support them and think this would not apply in this case. So what do you think about the order here? This case centers around the debate between the two sides, whether this law is constitutional and also whether it causes inconvenience to the states. The state and the judges here argue this law prevents schisms in the parties, which can happen if you get under two parties on the ballot, or if you lose one primary and get on the election. Somebody from, say, the Democratic Party might want to support the Democratic candidate, but they really liked the person who lost the primary, who's now running under the Green Party, like Mr. Platt. So they would be conflicted, and that would cause schisms in the party. So what do you think, friends? Do you think this is a valid argument? Do you think it matters? Of course, since we're against the two parties here, we might not mind if they have schisms, if people are diverted away from them. In the grand scheme, we also want to ask, what if it happened to two third parties? So we wouldn't want to cause schisms in third parties. So we got to consider whether we like this rule or not, the way it's applied in South Carolina here. The court argues no matter what happened, the Green Party could still nominate somebody else. By law, they could nominate Mr. Platt, but they could find someone else. Because Mr. Platt lost, he was out of contention for anything. So what do you think, friends? Do you like that reasoning? Our Green Party friends argue Mr. Platt should not have been out of contention for some of the reasons we mentioned. But the court says people could write him in nonetheless. They again talk about how the Green Party could nominate somebody else, so the Green Party, according to them, is not affected. They also mention how this can cause problems with voters, because if a candidate loses a primary, the voters may think they're out, they're not going to be a factor in the election, they're not going to be a candidate. But then if they go under another party, then they see them on the ballot, they're wondering what's going on here. I've never thought of that before, so I'm not sure how valid that is. Maybe you think it's valid, maybe you think it's not. Let me know. Ultimately, the court concludes as follows. For these reasons, we affirm the district court's holding that the South Carolina sore loser statute is For these reasons, we affirm the district court's holding that South Carolina sore loser statute is constitutional as applied to Platt's Green Party candidacy. Affirmed. End quote. Our friends did not win, but they challenged a law that third parties don't like. So we give them credit. Way to go, friends. Long live third parties. Goodbye.